Welcome, curious minds, to the Deep Dive. I'm your guide, and today, well, we're embarking on a truly fascinating journey right into the heart of India's constitutional framework. We've got a stack of detailed sources here all about one of the most significant offices really anywhere in the world, the President of India. Now, you might think you already know the President. Maybe you see them as, the ceremonial head, the first citizen, perhaps just a figurehead. But our mission today is to go far beyond those headlines. We're going to uncover the foundational legal provisions, some surprising details, and the really intricate machinery that creates, defines, and protects this absolutely pivotal role. We're talking about everything: how the president is chosen, the nuanced powers they hold, and even the, very stringent process by which they can be removed. It's a proper deep dive into the fabric of India's governance.
Indeed, and what's truly compelling here, I think, is how the Constitution meticulously crafts an office that brilliantly balances symbolic authority with very concrete responsibilities. And it does all this while reflecting India's unique republican and parliamentary character. We won't just be, rattling off articles. We'll be looking at the specific provisions, understanding not just what they say on paper, but really why they matter for every citizen and how these articles have been interpreted, how they've been shaped over the decades.
So, if you've ever found yourself wondering about the true significance of the President of India, or maybe how this office ensures continuity and stability in the world's largest democracy, then, get ready for some serious aha moments. We're going to try and distill these complex legal texts into clear, engaging insights, give you a comprehensive understanding of an office that truly anchors the nation. Let's unpack this. All right, let's start at the very beginning, right at the foundational layer, with Article 52 of the Indian Constitution. It's remarkably concise, almost, you could say, deceptively simple, but it's incredibly powerful in its implications. It just states, there shall be a President of India. That's it. No frills. Just a declaration.
What's immediately striking there, and frankly quite fascinating, is the mandatory nature of it. That word shall. It isn't just a suggestion, it's a constitutional command. It's not just creating a potential role or like a job opening. It's mandating the continuous, uninterrupted existence of a head of state for India. This single sentence unequivocally signifies India's republican nature. It explicitly states there will be no hereditary monarch, no king or queen, but an elected head of state. It makes the office indispensable, a perpetual part of India's constitutional framework.
So it's far more than just establishing a position. It's really a profound declaration of India's identity, asserting its status as a sovereign republic. It's almost like a foundational pillar, wouldn't you say?
Absolutely, it's the bedrock. It formally establishes the highest executive office, ensuring its continuous existence and, crucially, preventing any constitutional vacuum. This principle of continuity, it's so strong that even when a president's 5-year term expires, they don't immediately leave office. No, instead they continue to hold it until their successor officially takes over. That perfectly illustrates the idea that the office is never truly vacant. There's always someone embodying that symbolic ultimate authority. In essence, the president becomes the ultimate symbol of the Indian Republic, embodying its unity, integrity, and solidarity.
And yet you mentioned constitutional head. Now, that phrase often implies a largely symbolic role, doesn't it? So what does being the constitutional head of the republic truly mean for the practical powers of this office right from the outset with Article 52? Because, to a listener, constitutional head might sound like someone with immense direct power.
That's an excellent and absolutely crucial question. It's one that Articles 52 and 53 lay the groundwork for, but it really requires a deeper understanding of India's specific system. While the president is indeed the constitutional head, exercising powers, that exercise is, by constitutional convention and legal interpretation, generally on the aid and advice of the Council of Ministers. This is a key distinction in India's parliamentary system. It sets the president apart as a formal or de jure executive head, rather than a real or de facto executive head. The actual power, the day-to-day wielding of it, rests with the elected government. This understanding is paramount, and it was, extensively discussed and affirmed by landmark Supreme Court cases, like Shamsher Singh versus State of Punjab. That case firmly established the president's role. They exercise powers primarily on that aid and advice, as Article 74 further details. It was a very deliberate choice by the Constituent Assembly, actually, after a lot of debate. Some framers initially envisioned a stronger presidential role, but ultimately, the parliamentary system, similar to the British model, but with an elected president, won out, specifically to ensure ministerial accountability to the legislature.
Okay, so the president is always there, a symbol, a guardian, a constitutional bedrock. But how exactly do they wield power in practice if it's largely on this aid and advice? That brings us directly to Article 53, which, on the face of it, seems to describe quite vast powers. Article 53 is really where it gets, well, really interesting because it explicitly outlines these executive powers. Clause 1 states, "The executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution." When you read that, the phrase, "the executive power shall be vested in the President," sounds like a huge concentration of power.
It absolutely does sound like that, and it is a formal vesting of immense power. The president is the titular head of the entire executive branch. However, that crucial phrase you mentioned, in accordance with this Constitution, that's the golden thread running through everything. It's the key. So the president is the de jure head, the legal head. The prime minister and council, they're the de facto or real executive. This ensures that while all executive actions, all orders are formally taken in the president's name, the policy decisions, the political will behind them, and the implementation responsibilities, they ultimately rest with the elected government, which is accountable to Parliament.
That makes a lot of sense. So if the Union government, let's say, decides to launch a big new welfare scheme, the decision itself, the policy, comes from the Council of Ministers.
Yeah.
But the official government orders, the administrative directives that actually put that scheme into action, those are formally issued in the president's name. That's a perfect illustration, isn't it? Exercising power through officers subordinate to him, with the Council of Ministers being those key subordinate officers.
Precisely. It's a, well, beautifully designed mechanism, really. It combines the stability and dignity of a permanent head of state with the dynamism and accountability of an elected, responsible government. In Clause 2 adds another significant role that, again, on paper, sounds equally powerful. The supreme command of the defense forces of the Union shall be vested in the president. This makes the president the supreme commander of the Army, Navy, and Air Force, a truly weighty and symbolic title, signifying their ultimate constitutional authority over the armed forces.
That is an incredibly weighty title. It brings to mind images of a head of state directly overseeing military operations, maybe even issuing direct orders. Does that mean the president can unilaterally deploy troops, for instance, or declare war on their own initiative just because they're the supreme commander?
Not quite. And here again, that caveat, in accordance with this Constitution, is vital. Clause 2 explicitly includes another crucial qualifier. The exercise thereof shall be regulated by law. What this means is Parliament makes the laws concerning the armed forces command structure, their deployment, their functioning, even declarations of war or peace. The actual operational control, the deployment of troops, that's handled by the government under the political executive, the defense minister, and the Council of Ministers. So, while the president formally appoints the chiefs of staff and any declarations of war or peace are made in their name, the day-to-day command and strategic decisions are subject to parliamentary oversight and the advice of the Council of Ministers. Think of specific laws like the Army Act, Navy Act, Air Force Act. The president's role here is more ceremonial, a unifying figure for the armed forces, ensuring their allegiance to the Constitution and the nation, not to a political party. They might receive strategic briefings, yes, and their presence at parades symbolizes the nation's command, but they don't give operational orders.
This distinction, then, between the formal vesting of power and its actual exercise, it seems to be a recurring theme, a really fundamental theme in understanding the Indian presidency. It's a key takeaway.
It truly is foundational, absolutely central to the entire structure of India's parliamentary executive. And landmark court cases have continuously shaped this understanding. Ramjoya Kapoor versus State of Punjab, for instance, helped define executive power more broadly, clarifying it's not just implementing laws, but also the residue of governmental functions. Basically, everything that's not explicitly legislative or judicial, running state affairs, maintaining public order, foreign relations, all that. And as we discussed, Shamsher Singh versus State of Punjab definitively established that the president must act on the aid and advice of the Council of Ministers in exercising all their executive powers, except for a very limited set of explicitly discretionary situations.
Ah, those very limited, explicitly discretionary situations. You mentioned them a couple times now. This is where it really gets interesting for a listener, I think, because it's a departure from the standard aid and advice rule. Can you maybe elaborate on these, perhaps with some concrete examples? This feels like a potential aha moment, revealing where the president might have some real teeth, even if rarely shown.
Absolutely. And you're right, while the aid and advice rule is the bedrock, it's vital to acknowledge these critical, albeit rare situations where the president does exercise personal discretion. It's not about defying the Council of Ministers willy-nilly, but more about upholding the Constitution when that usual aid and advice mechanism is perhaps fractured or unavailable or even problematic. It's a heavy responsibility. So first, the president exercises discretion in appointing the prime minister when no single party or pre-election coalition gets a clear majority in the Lok Sabha, a hung parliament scenario. In such cases, the president has to use their own judgment to invite the leader they believe is most likely to be able to form a stable government and prove their majority on the floor of the House. This happened, for instance, in 1989, 1996, 1998. Presidents had to navigate really complex political landscapes then.
Okay, that's a big one. Choosing who gets the first shot at forming a government. What else?
Second, there's discretion in dissolving the Lok Sabha. Now, if a council of ministers loses the confidence of the House, but advises the president to dissolve parliament and call fresh elections, the president isn't necessarily bound to accept that advice, especially if they believe an alternative government could be formed without going back to the polls immediately. President Sanjeev Reddy, for example, faced this in 1979. He refused Prime Minister Charan Singh's advice to dissolve the Lok Sabha without Singh first facing parliament.
Interesting. So a check on a potentially weakened government trying to force an election.
Exactly. Third, the president has discretion in seeking information from the prime minister. This is under Article 78. It covers administrative affairs, legislative proposals. Now, it's not a direct power to overturn decisions, but it's a crucial right to be informed. And it can certainly be used to caution, to advise, maybe even influence behind the scenes.
The power of information and asking the right questions.
Precisely. And fourth, as you hinted at earlier, some of the legislative powers, particularly regarding bills, involve a degree of presidential discretion. We should probably unpack that next.
Right, because those discretionary powers you mentioned show the president isn't just a rubber stamp. They are a guardian capable of independent judgment, especially in moments of constitutional uncertainty or crisis. What about Clause 3 of Article 53? It talks about saving provisions, not transferring functions to the president, and allowing Parliament to confer functions on other authorities.
Yeah.
That sounds a bit technical, maybe just administrative detail.
You're spot on. It's largely about administrative efficiency and maintaining the federal structure. Clause 3A ensures that the president isn't suddenly burdened with existing state functions just because executive power is formally vested in them. It respects that division of powers between union and states. More importantly, Clause 3B gives Parliament flexibility. It allows them to create specialized bodies. Think of SEBI, the Securities and Exchange Board of India, regulating markets, or other statutory commissions, and Parliament can confer specific executive functions on them. It's about distributing the vast administrative load, allowing for specialization, while still maintaining that formal vesting of overall executive power in the president. A pragmatic approach to modern governance, really.
Okay, now you just mentioned some presidential discretion related to legislative powers. So beyond the executive domain, the president also plays a really crucial role in the whole legislative process. I'm thinking specifically about when a bill passed by both houses of parliament finally lands on their desk. Article 111 seems absolutely key here. What powers does the president actually have at that point?
You're absolutely right to highlight Article 111. It outlines the president's power regarding assent to bills. And this is where the president can indeed exert significant influence, sometimes acting as a crucial check on Parliament itself. When a bill has been passed by both houses, it's presented to the president. They then have three main options, often referred to as veto powers, though the Constitution doesn't use that exact term.
Okay, three options. What are they?
First, there's what effectively an absolute veto. The president can simply withhold their assent altogether. If this happens, the bill just doesn't become law, full stop. Now, this power is quite rare for regular union government bills, but it has been exercised historically. For example, on private member bills, or maybe on state bills that were reserved by a governor for the president's consideration. President Rajendra Prasad used it on the PPSU appropriation bill back in 1954, citing constitutional concerns.
So just a flat no. What's the second option?
Yeah. Second is the suspensory veto. Here, the president can return the bill provided it's not a money bill to Parliament for reconsideration. They might suggest amendments, point out issues they see. If Parliament then repasses the bill, either with or without the suggested amendments, and presents it again to the president must give their assent. They don't get to return it a second time. A notable instance was President APJ Abdul Kalam returning the Office of Profit Bill in 2006 for reconsideration. Parliament did reconsider, but then repassed it, and he had to assent.
Right, so they could delay it, force a rethink, but ultimately Parliament gets the final say if they insist. What's the third one? You said it was maybe the most intriguing.
Yes, the pocket veto. This is perhaps the most unique and uniquely Indian type of veto power. The Constitution, crucially, doesn't prescribe any time limit within which the president must act on a bill presented for assent. So the president can simply choose to do nothing, neither assent to the bill nor return it for reconsideration. They effectively just sit on it indefinitely. This is known as a pocket veto. The president metaphorically puts the bill in their pocket and it simply lapses. It never becomes law.
Wow. No time limit at all.
None specified. A famous instance was President Gianni Zail Singh's use of the pocket veto on the Indian Post Office Amendment Bill in 1986. It was quite controversial at the time due to concerns about civil liberties implications in the bill. He just never acted on it.
Wow. Those veto powers truly demonstrate the president isn't just ceremonial. Especially the pocket veto. That's a silent but incredibly powerful mechanism. It definitely adds some real teeth to the office. And what about during times of crisis within the states? I've heard the term president's rule used quite often in news reports. That sounds like a very direct and impactful power. Does the president have a hand in that too? Maybe under Article 356?
You're absolutely right to bring up president's rule under Article 356. This is another area where the president, though crucially acting on the advice of the Union Council of Ministers, holds a very significant and, yes, often controversial power to intervene directly in state governance. This article allows the president to impose direct central rule in a state if they are satisfied based on a report from the state governor, or even otherwise that a situation has arisen where the government of the state cannot be carried on in accordance with the provisions of the Constitution.
Or otherwise, meaning the central government could potentially initiate it even without the governor recommending it.
Potentially, yes. The wording allows for it, though typically it follows a governor's report. When president's rule is imposed, the practical effect is quite dramatic. The president takes over all or any of the functions of the state government, and the powers vested in or exercisable by the governor or any other state authority, except the state legislature itself. The president can even declare that the powers of the state legislature shall be exercisable by or under the authority of Parliament. Essentially, the state's executive, and often its legislative functions too, come under the direct control of the union government, operating through the president. It's a major shift in the federal balance.
That sounds like an immense power and, yeah, potentially very disruptive to a state's autonomy. Has it been controversial over the years?
Highly controversial. From its inception, Article 356 has been invoked, well, hundreds of times, and it's often been criticized as a political tool used by the central government to dismiss state governments led by rival parties, sometimes on grounds that critics argue weren't a genuine breakdown of constitutional machinery. However, the landmark Supreme Court judgment in S.R. Bomai versus Union of India in 1994 significantly curbed the arbitrary use of this power. The court ruled, very importantly, that the president's satisfaction is subject to judicial review. Courts can examine the grounds for imposing president's rule. This judgment established that the power should really only be used as a last resort and only for a genuine constitutional breakdown, not for political convenience. It put important checks and balances back into the system.
Okay, so we have this indispensable office symbolizing the nation, federal character, formal powers largely on advice, but with these crucial discretionary checks, legislative checks, even emergency powers like Article 356. But how does one actually become the president of India? Not a direct popular vote, which might surprise some listeners outside India. Article 54, election of president, gives us the blueprint, right?
Yes, Article 54 meticulously lays out the Electoral College, and it's designed to ensure broad-based representation, which is really a hallmark of India's unique system. It is indeed an indirect election, not by the people directly, but chosen instead by their elected representatives. The Electoral College consists of, firstly, the elected members of both houses of Parliament, that's the Lok Sabha and the Rajya Sabha, and secondly, crucially, it includes the elected members of the legislative assemblies of the states. This inclusion of state legislatures is absolutely vital. It reflects India's federal structure and ensures that the states have a significant voice in choosing the head of state.
Hold on, just checking. You emphasized elected members both times. So if there are nominated members in the Rajya Sabha or maybe in a state legislative council or assembly, they don't get to cast a vote for president. That's an important detail.
That's absolutely correct, and it's a very deliberate choice in the Constitution. Only those directly elected by the people or indirectly elected by the people's representatives, in the case of the Rajya Sabha, get to participate. This ensures the president's mandate stems purely from the people's representatives. Nominated members, often chosen for expertise, are excluded to keep the election based on democratic mandate. And, as you know, a vital amendment, the 70th Amendment Act back in 1992, also included the elected members of the legislative assemblies of Delhi and Puducherry. That brought these union territories with legislatures into the fold for this election, giving them a voice too.
Right. So why an indirect election? Why not just have everyone vote directly, like for the U.S. president? What was the thinking behind this indirect approach?
The object was quite profound and really twofold. First, the idea was to make the president a symbol of the entire nation, someone who stands above the rough and tumble of partisan politics, not beholden to a single constituency or region like an MP might be. A directly elected president, with their own nationwide popular mandate, could potentially claim a mandate equal to or even rivaling that of the prime minister. This could lead to conflict and instability in the executive. The framers were very keen to avoid creating two competing centers of power.
Okay, avoiding conflict between PM and president. What was the second reason?
The second reason profoundly reflects India's federal character. By giving the elected members of the state assemblies a significant, weighted voice in the election, it ensures the states are partners in choosing the head of state. It strengthens that union-state balance. The Supreme Court, in cases like in the presidential election 1974, even clarified that the election must proceed and cannot be postponed just because a state legislative assembly might be dissolved at the time. It underscores how constitutionally imperative the timely completion of this process is.
It really does sound like a very carefully constructed system, designed to balance national unity and federal representation. But how do you make sure the votes from different states, Uttar Pradesh with its huge population versus Sikkim, which is much smaller, are fair? How do you weigh them properly? That must get complicated.
That's precisely what Article 55 gets into, the meticulous manner of election of president. This is where the mathematical intricacies of vote valuation come into play, and it's specifically designed to balance those very concerns: fair representation for states of different sizes and parity between the states and the union.
Okay, let's dive into the nitty-gritty then. The mechanics of vote value calculation under Article 55. It sounds mathematical, but it feels crucial for understanding this federal balance. It's not just one representative, one vote.
Absolutely not. Article 55 fundamentally aims for two key things. First, uniformity in the scale of representation among the different states, and second, parity between the states as a whole and the Union Parliament. Think of it less as one person, one vote within that electoral college, and more as one population block, one proportional vote. It's a rather brilliant system designed to prevent smaller states from being completely drowned out by the larger ones, and it ensures a balance between the collective voice of the states and the collective voice of the union representation. It aims to make the president truly representative of the entire Indian polity.
So how exactly is the value of an MLA's vote calculated? Let's take an elected member of, say, the West Bengal Legislative Assembly. How much is their vote worth?
Okay, it's a specific two-step formula. You start by taking the total population of that state, West Bengal, in your example, and this is the critical detail we flagged earlier. The population is taken as ascertained from the 1971 census. We'll come back to why in 1971 in a moment. You divide that 1971 population figure by the total number of elected MLAs in the West Bengal Assembly. This gives you an initial quotient. Then, in the second step, you divide that quotient by 1,000. If the remainder you get in this final division is 500 or more, you round up and add 1 to the final vote value. Otherwise, you ignore the remainder. So what this means mathematically is that a state with a larger population relative to the number of its MLAs will have MLAs with a higher individual vote value. It numerically reflects the larger population base they represent.
So the vote of an MLA from Uttar Pradesh, with its huge population, carries significantly more weight than the vote of an MLA from a smaller state like Goa or Mizoram.
Precisely. It ensures that the population of each state is adequately reflected in the total value of votes coming from that state.
Okay, that makes sense for the state's representation. Now, how do the MPs, the members of parliament in the Lok Sabha and Rajya Sabha, get their votes valued in this intricate scheme? Is it the same formula?
No, their vote value is determined by a different calculation, and this one is specifically designed to achieve that parity between the states and the union. You take the total value of all elected MLA's votes from all states combined, add up all those values we just calculated, then you divide that grand total by the total number of elected MPs from both houses of parliament, the Lok Sabha and the Rajya Sabha combined. Again, if there are fractions exceeding 1/2 in this final division, they're rounded up to 1. Otherwise, fractions are disregarded. This calculation ensures that the collective voting strength of the Union Parliament is, as nearly as possible, equal to the collective voting strength of all the state legislative assemblies put together. It achieves that critical balance Article 55 seeks.
Wow. So the total weight of all MP votes roughly equals the total weight of all MLA votes nationwide. That's a very elegant way to ensure the president represents both the federal voice of the states and the union voice of the national parliament in a balanced way.
It really is. The system is profoundly designed to ensure the president represents the collective will of both the union and its constituent states. It's not about a simple majority derived from a first-past-the-post approach. It aims for a president with a genuinely broad base of support across the country.
And you mentioned the voting system itself reinforces this.
Exactly. The actual voting uses the system of proportional representation by means of the single transferable vote, often abbreviated as PRS-TV. And it's done by secret ballot. This system lets the electors, the MLAs and MPs, rank the candidates in order of preference. First choice, second choice, third choice, and so on. They don't just pick one candidate. If no candidate secures an absolute majority, which means more than 50% of the total value of valid votes cast based on the first preference votes alone, then the candidate with the fewest first preference votes is eliminated. And their ballot papers are examined, and the second preference votes marked on them are transferred to the remaining candidates according to those preferences. This process of elimination and vote transfer continues in rounds until one candidate crosses that 50% threshold, securing the required absolute majority.
So it ensures the winner eventually has a majority support, even if it requires considering second or third preferences. It forces consensus building.
Precisely. It ensures the elected president enjoys broad acceptance within the Electoral College, reflecting a wider consensus among the diverse political representations from across the country.
Now, back to that 1971 census detail you mentioned. Using population figures from over 50 years ago seems, well, counterintuitive for electing the head of state today in a country that's changed so much. Why freeze it so far back and keep it frozen until at least after 2026?
That's a really significant and quite deliberate policy choice. It wasn't accidental. It has deep socio-political reasons behind it. The Constitution, 84th Amendment Act, back in 2001, effectively froze the population figures used for presidential elections and also for delimiting parliamentary and assembly constituencies to the 1971 census levels. And this freeze lasts until the first census figures published after the year 2026 become available.
But why? What was the rationale?
The primary reason was to avoid penalizing those states, particularly in southern India, that had been more successful in implementing national family planning policies and controlling population growth. If their populations grew slower as a result of these successful policies, using a more recent census, say from 1991 or 2001, would have actually reduced their proportional representation and electoral weight in presidential elections and in parliament. This would have effectively disincentivized states from pursuing national population control objectives. So, freezing the numbers based on the 1971 census was a measure to encourage national policy without adversely affecting the political representation or electoral power of those states that were successfully implementing it.
That truly is a classic aha moment right there. A seemingly dry technical detail using the 1971 census has these profound and forward-looking socio-political implications. It shows how constitutional amendments try to balance different national goals.
Exactly. It shows the foresight in considering the potential unintended consequences of demographic shifts on political representation and national policy.
So, once a candidate has been elected through this meticulously designed and rather complex process, how long does the president serve? What's the term of office? Once the president has successfully navigated that complex electoral college and officially taken office, Article 56 comes into play, outlining their term of office. It seems to establish a clear tenure.
Indeed. The president holds office for a fixed term of 5 years, starting from the date they officially enter upon their office. This fixed term provides crucial stability. It gives consistency to the highest office of the state, allowing for stable leadership at the head of the republic, insulated, to a degree, from the day-to-day shifts in politics. However, while the term is fixed at 5 years, the Constitution also includes provisions for the office to be vacated before the end of those 5 years, ensuring the system remains dynamic and accountable.
Like resignation, I imagine. That must be one way.
Yes, that's one possibility covered in Article 56(1)(a). The president can resign at any time by writing under their hand addressed specifically to the vice president. And importantly, Clause 2 of Article 56 adds a procedural step. The vice president, upon receiving the resignation, must immediately communicate it to the Speaker of the Lok Sabha, the House of the People. This ensures transparency and promptly informs the directly elected representatives about such a significant event, upholding that democratic accountability loop.
Okay, resignation is one way, and then there's the ultimate accountability mechanism, the one that sounds incredibly serious, a real last resort, impeachment.
Precisely. Article 56, 1b mentions that the president can be removed from office for violation of the Constitution through the specific, highly stringent impeachment process detailed later in Article 61. This is a very serious quasi-judicial procedure deliberately made difficult to invoke. It underscores that even the head of state is ultimately accountable under the Constitution for grave misconduct, but also protects them from being removed capriciously or for purely political reasons.
A constitutional safeguard on both ends, then. And to prevent any kind of power vacuum right at the end of a president's 5-year term, what happens if, for some reason, a successor isn't immediately ready to take office precisely at the 5-year mark? You mentioned continuity earlier, and it seems vital here.
That's handled by a crucial proviso in Article 56, specifically Proviso C. It states that the president continues to hold office, notwithstanding the expiration of his term, until their successor enters upon office. This ensures an absolutely unbroken chain of command and continuity of governance. It's a fundamental constitutional bedrock. The office of the president is never truly vacant. There's always someone performing its functions. Furthermore, Article 62 reinforces this. It explicitly mandates that an election to fill a vacancy caused by the expiration of the term must be completed before the expiration of that term. It proactively solidifies this commitment to seamless continuity.
It really is all about stability and ensuring an orderly transition, meticulously designed to avoid any uncertainty at the very top. Now, speaking of terms, can a president serve more than once? Does Article 57, eligibility for re-election, address this?
Yes, it does, and Article 57 is remarkably straightforward on this point. It states that a person who holds or who has held office as president shall, subject to the other provisions of this Constitution, be eligible for re-election to that office. This means basically as long as they still meet all the other qualifications laid out in the Constitution, like age, citizenship, etc., there's no inherent constitutional bar preventing them from being elected again just because they've already served a term or even multiple terms.
So unlike some other major republics, the United States being the obvious example, with its strict 2-term limit, there are no term limits for the president of India. Theoretically, could a very popular president keep getting reelected?
Theoretically, yes, that's quite a notable distinction. The Indian Constitution deliberately does not impose any limit on the number of terms a person can serve as president. It seems to be a choice to rely more on political convention, the judgment of the Electoral College, and the democratic process itself, rather than a hard constitutional prohibition. It allows the nation the flexibility to potentially benefit from an experienced leader for a longer duration if the Electoral College so chooses and the individual can secure re-election. Interestingly, in practice, our first president, Dr. Rajendra Prasad, remains the only one to have actually served 2 full terms. Since then, the convention has largely been for presidents to serve only 1 term.
Fascinating. A reliance on convention over constitutional text in that regard. Now that we know about the term and re-election, let's talk about Article 58, qualifications for election as president. We've established it's a very high office. But what does it actually take to even be considered? Who is eligible?
Right. Article 58 sets the baseline criteria, the fundamental qualifications needed to even stand for election. To be eligible, a person must meet 3 mandatory conditions. First, they must be a citizen of India. Second, they must have completed the age of 35 years. And third, they must be qualified for election as a member of the House of the People, the Lok Sabha. This last requirement implies they need to meet the general criteria for being an MP. Things like being a registered voter in any parliamentary constituency and not being disqualified under other relevant laws, such as the Representation of the People Act. It ensures a candidate has a certain maturity, citizenship, and a basic connection to the democratic process.
Okay, those seem like fairly standard requirements. Citizenship, a minimum age, and general fitness to hold legislative office. But what about specific disqualifications? Is there anything that would actively prevent an otherwise qualified person from running beyond just not meeting those 3 points?
Yes, there's a very important one laid out in Clause 2 of Article 58. It states that a person shall not be eligible for election as president if they hold any office of profit under the government of India or the government of any state, or under any local or other authority subject to the control of any of the said governments. This is a critical constitutional principle. It's designed primarily to ensure the president's impartiality and independence once in office and to prevent potential conflicts of interest.
Office of profit. That phrase comes up a lot in Indian politics, often leading to legal challenges for various elected officials. Can you clarify what it really means in this context? It seems like it could be interpreted quite broadly.
It is a key doctrine, and you're right, its interpretation has evolved through court judgments. Generally, it refers to an office that has the potential to yield profit or financial gain, where the appointment and removal processes are under government control, or where the government exercises some significant financial or administrative control over its functions. Crucially, the person doesn't actually have to be making a profit from it. The mere capacity of the office to yield profit or potential for remuneration or undue influence from the government is often the deciding factor. The core aim here is to ensure that the president, if elected, remains impartial and free from any executive influence that might arise from holding another position seen as being under government patronage or control. Landmark Supreme Court cases like Guru Gobinda Basu and Jayabhasan, while dealing with MPs or MLAs, have laid down principles that apply with even greater force to the president, emphasizing the need to avoid any perception of conflict or dependence.
But the Constitution does make some specific exceptions, doesn't it? The explanation attached to Article 58 mentions certain high offices that are not considered offices of profit for this purpose.
Correct. The Constitution carves out specific exemptions to ensure the political process isn't unduly hindered for high constitutional functionaries who might want to contest. Holding the office of president itself, or vice president, or governor of any state, or being a minister either for the union or for any state, these positions are explicitly declared not to be offices of profit for the purpose of disqualification under Article 58. This allows these individuals, who are already serving in significant public roles defined by the Constitution, to contest the presidential election without having to resign their current posts first. It facilitates a smoother political transition or continuation, recognizing these roles as public service duties rather than private profit-making ventures.
That makes practical sense. It balances the principle of impartiality with the realities of public service. So, once someone is elected, what are the actual conditions of president's office, as laid out in Article 59? What rules must they follow once they assume this incredibly important office?
Article 59 really re-expected of the presidential office. First, and critically important, Clause 1 states that the president cannot simultaneously be a member of either House of Parliament or of a House of the Legislature of any state. If a sitting MP or MLA is elected president, their seat in that legislative body is deemed to have been automatically vacated on the date they enter upon their office as president. This ensures the president is completely detached from day-to-day party politics, free from legislative duties and partisan pressures, and can dedicate themselves solely to their constitutional role as the nonpartisan head of state representing the entire nation.
So that office of profit rule we just discussed for qualification, does that continue to apply during their entire term as president as well?
Indeed it does. Clause 2 of Article 59 explicitly states that the president shall not hold any other office of profit during their term. This reinforces the disqualification condition from Article 58 and ensures that impartiality and singular focus are maintained throughout their tenure. It's a continuous, unwavering requirement designed to protect the absolute integrity of the office.
And then there's the practical side, their official residence and their finances. These seem important for maintaining the necessary stature and dignity, allowing them to perform duties without personal financial worries.
Absolutely. Clauses 3 and 4 of Article 59 address that essential aspect. Clause 3 entitles the president to the use of their official residences, most famously, Rashtrapati Bhavan in New Delhi, without payment of rent. They are also entitled to such emoluments, allowances, and privileges as may be determined by Parliament by law. Until Parliament makes such a law, the details are specified in the second schedule of the Constitution itself. And critically, this is a vital protection for the office's independence. Clause 4 stipulates that the emoluments and allowances of the president cannot be diminished during their term of office. This provision ensures the president's financial independence and shields the dignity of the office from any potential political pressure through budget cuts or financial manipulation. Parliament can certainly increase them for a sitting president, but they can never decrease them.
We've covered how the president gets elected, the qualifications, the conditions of service. But before they can officially start performing any duties, there's that profoundly symbolic and constitutionally mandated act, the oath. Article 60, oath or affirmation by the president.
Yes, and this isn't just a formality or a piece of ceremony, it's a constitutional binding of the highest order. It's a solemn pledge that underpins their entire role. The president, or indeed anyone acting as president, or discharging the functions of the president, like the vice president in certain circumstances, must, before entering upon his office, make and subscribe a solemn oath or affirmation in a specific form. And it's administered by the Chief Justice of India, or if the CJI is unavailable, by the senior-most judge of the Supreme Court available. Having the highest judicial authority administer the oath underscores its immense gravity and its connection to the rule of law.
And the wording of that oath, it's incredibly specific, isn't it? It's not just a general pledge to do a good job. The president swears or affirms that they will faithfully execute the office and will, to the best of my ability, preserve, protect, and defend the Constitution and the law. That phrase, preserve, protect, and defend, sounds like a very heavy, very active responsibility. It positions them as a paramount guardian.
It's absolutely the core of the president's duty and their unique identity within the constitutional framework. That specific part of the oath elevates the president beyond just being the executive head. It makes them a supreme guardian of the Constitution itself. It's a powerful statement of constitutional morality. It implies not just passive acceptance, but an active duty to safeguard the constitutional order, to ensure that governance adheres to its fundamental principles, perhaps even in how they exercise their advisory role or limited discretion. This pledge to preserve, protect, and defend is a foundational tenet of constitutionalism everywhere, reinforcing that all state power is ultimately derived from and limited by the Constitution. They also pledge, importantly, to devote myself to the service and well-being of the people of India. This underscores the democratic and welfare-oriented nature of the Indian state, binding the head of state directly to the ultimate sovereigns, the people.
It really solidifies their commitment to the rule of law, to the Constitution itself, and to the nation. But what happens if that sacred oath, that profound commitment to preserve, protect, and defend the Constitution is seen to be violated in a grave manner? What is the ultimate procedure for impeachment under Article 61? This is truly the constitutional nuclear option, isn't it? To be used only in the most dire circumstances.
This is indeed the ultimate check, Article 61. It outlines a truly stringent, quasi-judicial process designed only for the gravest charge, violation of the Constitution. Now, interestingly, the phrase violation of the Constitution isn't explicitly defined within the Constitution itself. Its interpretation is left to Parliament during the impeachment process, but it's universally understood to mean serious fundamental transgressions that undermine the constitutional framework, things far beyond mere policy disagreements or political errors. And the charge can be initiated by either House of Parliament, the Lok Sabha, or the Rajya Sabha can start the process.
How does that initiation process actually begin? It must require substantial support, surely, given the immense gravity of trying to remove a head of state. It can't be something done lightly or frivolously.
Absolutely. It requires significant backing right from the start. To even initiate a charge, the proposal must be contained in a resolution moved after at least 14 days written notice. And that notice must be signed by not less than 1/4 of the total number of members of the House intending to move the resolution. So a quarter of the House needs to sign on just to give notice. Then that resolution containing the charge needs to be passed by a majority of not less than 2/3 of the total membership of that initiating House. Not just 2/3 of those present and voting, but 2/3 of the total strength of the House. These are very high thresholds.
Extremely high. Deliberately so, I imagine.
Deliberately put in place, yes, to ensure that an impeachment proceeding isn't launched lightly, perhaps for partisan reasons, or without an overwhelming cross-party consensus, or at least very broad support from a wide spectrum of representatives. It's designed to be a deeply considered national action, not a political game.
And then, once one house prefers the charge with that special majority, the other house steps in to investigate. It sounds like a rigorous two-stage process.
Correct. If one house passes the resolution preferring the charge, the other house then investigates that charge. Or it can cause the charge to be investigated perhaps by setting up a special committee of inquiry involving members of that house or even outside experts. And crucially, during this entire investigation process, the president has the fundamental constitutional right to appear and to be represented. They can defend themselves, either through legal counsel or in person. This ensures that the principles of natural justice, the right to be heard, the right to defend oneself against accusations, alteram partem, are fully upheld, even when the highest office in the land is under scrutiny. It's a formal constitutional inquiry, not a political trial in the informal sense.
And to actually remove the president from office what majority is needed in that second investigating House after all of that investigation and the president's defense.
Following the investigation and the president's representation, the investigating House must also pass a resolution sustaining the charge. And this resolution must also be passed by a majority of not less than two-thirds of its total membership. Only if and when the investigating House passes this resolution with that same special majority declaring the charge has been sustained, is the president deemed to have been removed from office. The removal takes effect from the date on which that resolution is passed. These special majorities required in both houses underscore the immense gravity of the action. It demands broad, likely bipartisan consensus to remove the head of state. And it's perhaps a testament to the stability of the office, the respect it commands, and the sheer difficulty of this process that, to date, no president in India has ever actually faced a completed impeachment process. None have been removed.
That's a powerful fact in itself. It speaks volumes about the robustness of the office and the stringency of the process, reflecting a deep respect for the institution and the need for stability above all else. So, wrapping up the life cycle, as it were. What happens if the office of the president suddenly becomes vacant for any reason, say due to resignation or death, or that unlikely impeachment, or even if the fixed term simply ends and a new president needs to be sworn in? How does the Constitution ensure that seamless continuity we talked about earlier?
That's a crucial final piece, and the Constitution has meticulously planned for exactly this to ensure there's absolutely no lapse, no vacuum in the highest office. Article 62 specifically covers the time of holding election to fill vacancy in the office of president. It addresses two scenarios. Firstly, if a vacancy is going to be caused by the expiration of the president's fixed 5-year term, the election to fill that vacancy must be completed before the term expires. This proactively prevents any interregnum, any gap, ensuring a seamless handover.
Okay, that covers the routine end-of-term situation. But what if it's an unexpected vacancy, a sudden one, due to death or resignation or removal by impeachment? These things can happen without warning. How quickly must a new president be put in place then, and who fills the gap in the meantime?
In those cases, Article 62 applies. Where the vacancy occurs suddenly due to death, resignation, or removal, an election to fill that vacancy must be held as soon as possible after the occurrence of the vacancy, and in any case not later than 6 months from the date the vacancy occurs. And during that interim period, between the vacancy occurring and the new president being elected and taking office, which could be up to 6 months, the Constitution provides a clear mechanism. The vice president steps in under Article 65 to act as president or to discharge the president's functions. This constitutional provision ensures the office is always occupied, constitutional duties are always performed, and the stability of the state is maintained even during that transition.
So the vice president provides that immediate continuity. And the person eventually elected to fill that sudden vacancy, do they serve just the remainder of the previous president's term or a full term?
That's another important point in Article 62. The person elected to fill such a casual vacancy holds office for a full 5-year term from the date they enter upon their office. They don't just complete the leftover tenure of the previous president. This ensures the newly elected president has a full, fresh mandate and provides stability going forward.
So the Constitution has truly thought of every contingency, it seems. From establishing the office, defining its powers, formal and discretionary setting, the election method, term, qualifications, conditions, oath, removal, and finally, ensuring continuity. It's all there.
Absolutely. The intricate web of Articles 52 to 62, along with other related provisions we touched upon, like Article 74, aid and advice, Article 111, vetoes, Article 78, information, and even Article 356, President's Rule, meticulously lays down the entire framework. It covers the establishment, election term, re-election, qualifications, conditions, oath, powers, and even the removal process for the President of India. Each provision works in concert, really, to uphold the dignity, the independence, and the unique Republican and parliamentary character of this vital constitutional post. It ensures it remains a pillar of India's democratic governance, a true constitutional sentinel.
What an incredible, comprehensive deep dive. From that fundamental declaration of India's republican nature back in Article 52, establishing the office as continuous and indispensable, all the way through the elaborate mechanics of the Electoral College in Article 55, the nuances of executive and legislative power, the solemn oath in Article 60, and that high-threshold impeachment process in Article 61. We've truly seen how the Indian Constitution meticulously crafts the office of the president. It's clearly an office that symbolizes national unity, ensures continuity through very careful provisions, acts as a constitutional guardian, and importantly, wields crucial, albeit limited, discretionary and legislative checks.
all while operating within that delicate balance of a parliamentary democracy, where the real day-to-day executive power largely rests with the Council of Ministers.
This deep dive really does reveal the president as a fascinating blend, doesn't it? Part ceremonial head, a unifying national symbol, and part constitutional sentinel. The emphasis on that indirect yet broadly representative election method in Articles 54 and 55, the detailed rules for vote calculation to achieve uniformity among states and parity with the Union, the stringent accountability mechanisms like impeachment, and even those carefully defined discretionary and legislative powers we discussed, they all underscore a system designed for stability, for dignity, and for a profound, solemn commitment to the rule of law. It's really a testament to the wisdom and foresight embedded in India's founding document. It created an office that is both powerful in its symbolism and very precise in its constitutional functions.
So, what does all this mean for you, the listener, the well-informed citizen? Well, it means that understanding the president's role isn't just about knowing a name or recognizing a face in ceremonies. It's really about grasping the very foundation of India's governance structure. It's about appreciating the ends and ensure continuity, even, or perhaps especially, in challenging times. It's about recognizing the quiet, yet potentially profound influence embedded within this office. And maybe here's something to mull over as we conclude. Given the president's explicit solemn oath to preserve, protect, and defend the Constitution and the law, and their unique position as the formal, nonpartisan head of state, how might the subtle influence, the moral authority of the president play a crucial, perhaps unwritten role in times of genuine constitutional crisis, even when they're operating largely on the aid and advice of the Council of Ministers? Does that powerful oath give the office a kind of quiet power, a power of persuasion, maybe caution, or even ultimate constitutional vigilance that isn't explicitly written down in the articles, but is perhaps deeply understood as part of the role spirit?
That's a truly thought-provoking question. It invites all of us, really, to consider the unwritten conventions, the spirit behind the constitutional text, and the profound moral weight that such a high office carries. It encourages us to look beyond just the letter of the law to its deeper implications for the health and resilience of our democracy.
Thank you for joining us on this deep dive into the Indian presidency. We hope you feel more informed, definitely more curious, and ready to explore the many nuances of our Constitution. Until next time, keep digging.